present here in the courtroom today. This is the date and time set for a sentencing hearing in this matter. If I could have counsel put your appearances on.
Sierra Coke on behalf of the people.
And Troy Dan, Your Honor, appearing on behalf of Mr. Kurt Pritchard, who's standing to my left.
Mr. Pritchard, have you had an adequate opportunity to go through the pre-sentence report and talk to Mr. Daniel about that?
I have, Your Honor.
Mr. Daniel, are there any additions, deletions, or corrections to that report?
Just one minor correction, Your Honor. The page one subsequent to the recommendation page at the top paragraph on the evaluation plan, second line, it says that Mr. Pritchard has pled to operating while intoxicated third offense. Technically, he pled to operating while visibly impaired third offense. It's a slight distinction, and it made a difference at his license sanctions, actually. His prior was so long ago that it was treated as a first offense, impaired driving versus a OWI, which has a different license suspension period. So anyway, it's a minor, that's the only error I found, Your Honor.
Any objection to that change?
No, he's correct.
Any challenges to the scoring, Mr. Daniel?
No, Your Honor.
Ms. Cope, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, it is scored properly.
Anything on behalf of the people for allocation today?
Mr. Pritchard's guidelines are low. They're 0 to 6. The reason they're low is because there's a 10-year gap. He presents at 66 years old with 5 felonies, 6 prior misdemeanors, and a juvenile record. But to his credit, he has not had any interaction with the criminal justice system since his operating while intoxicated third offense in 2008. In this case, it involved him flipping his truck at a .185. He's lucky to be with us here today and not hurting himself or others. He's 66 years old, definitely old enough to know better. Most of his criminal history comes from when he was in his youth. I think they were in the 70s. In fact, I think the recommendation is appropriate. Normally, I wouldn't agree with that type of a recommendation, this being his 4th OWI offense in his life. But like I said, it's been 17 years since he's had any interaction with the criminal justice system. Thank you.
Mr. Daniel.
Thank you, Your Honor. As noted in the court received a copy of a pretrial supervision report that Mr. Pritchard did contact them immediately upon release from jail, that he's been 100% compliant with his check-ins. He did his first 60 days of daily PBTs, and then he voluntarily continued on with that. He's up until just yesterday. So he's been doing voluntary PBTs the whole time. Well, after the first 60 days, the first 60 days were required. Also, that he's attended AA meetings once or twice a day, almost every single day since the incident, June 13th. He actually has a couple of fellows here, 3 fellows there who are his support people from AA meetings. They're here to support him. Again, he's since his plea on November 6th, he hasn't missed an AA meeting except last Sunday they were closed because the power went out. But otherwise, he's been attending his AA meetings on a regular basis. Additionally, he got a substance abuse evaluation from the Grace Center, and he's been counseling with them twice a month. Also, Mr. Pritchard does realize that he's an alcoholic. He has a past history. He's been out of trouble since 2009, and he's had prior history for drinking and driving. He understands that now. Obviously, it's been a little later than it should have been, but he understands now that he can no longer drink alcohol, that he is an alcoholic, and he knows that he needs to, maintain his sobriety the rest of his life. He knows what he did was wrong, and through his actions, he put himself at risk, and he knows that he deserves to be punished. However, his conduct, he's demonstrated since his arrest, he's taken all the ameliorative steps. Again, he's voluntarily doing a preliminary breath tests. He's going to counseling. He's going to AA. He's put himself in a good position here to avoid being a repeat offender, Your Honor, and ask the court to take that consideration. Another recommendation is at 60 days, ask the court just to consider 30 days, but 30 days be held in abeyance pending successful completion of probation, Your Honor. Thank you.
Thank you. Excuse me, Mr. Pritchard, was there anything you wanted to say?
Yes, first I'd like to apologize to the community, the Grayling community, for my actions that are unacceptable. I do realize that I have an alcohol problem, and I'm trying to address that in a stringent manner. I've got a good support group behind me in the program. I was in the program years ago. Sponsor died. I ended up drifting away and ended up going back into drinking, and it just got worse and worse. And I'm ready to admit that I do have a problem with alcoholism and that needs to be addressed. And trying to keep myself in a positive, forward manner to be able to recover from this and not drink. And again, my apologies to the community for my actions. Like the prosecutor said, that, I'm still alive, and I'm glad that I didn't hurt anybody else.
I did read through the report. I'm familiar with your background and your circumstances, generally based on the information in that report. I'm also familiar with what happened in this particular case, based on the recitation of the police report that's in there. So I feel like I've got a good handle on your situation overall, including your actions in this case. I think there are certainly some positives here. Number one, the fact that you did go for 17 years without any contacts. You managed to move on from what does appear to be some problems in your early life. And for a sustained period of time, did not have any involvement. That's absolutely positive, because what that shows the court is that there's potential for rehabilitation from this incident, that you go back to the way you have been for 17 years. I think the fact that you are getting involved in AA recovery community, that you're taking it seriously, is also a positive. Again, that shows the court that there's potential for rehabilitation here. I think, your situation is a really striking example of how alcoholism is a lifelong battle. You can go for as long as you did without any contacts. Not that you weren't drinking through all of that period of time, but how, you can have problems, be okay for a long time, and then the problems just start right up again. And so I hope that that's something that you look at as proven evidence that you just cannot go back to drink for the rest of your life, and that it is going to be a lifelong battle.
It is.
And I think the fact that you're looking at it that way is a positive, again, because I think that's shows the court that there's the potential for rehabilitation. Obviously, on the downside, this is your fourth time, down this road of alcohol-related driving offenses. That is a concern to the court. Part of what I have to look at is protecting the community. I'm well familiar with Wilcox Bridge Road. I drive that road all the time. There's pretty nasty curves there, not curves that I would want to try to navigate with the kind of blood alcohol level that you had. I think you're extremely lucky that you weren't more seriously injured or killed. And the other driver that you encountered, I think, is really lucky that this is the worst you could be here under much different circumstances right now. So that is a concern. And your actions in engaging in this, again, for the fourth time, I think warrant a degree of punishment. I think the recommendation is well crafted to address all aspects that I've mentioned. I think a period of probation, ensure that you stay on the right track with supervision for a period of time is appropriate. And I think probation also acknowledges the potential for rehabilitation. I think the guidelines are 0 to 6 months. I think a sentence at the low end of the guidelines is appropriate to address the punishment aspect of this and the deterrent aspect of this that I mentioned as well. So for all of those reasons, I'm going to follow the recommendation in the report, and that is to sentence you to probation for a period of 2 years. The court is going to adopt as the conditions of that probation all the terms and conditions listed in the report. The court is going to order that you serve 60 days in the Crawford County Jail with credit for 1 day served. The court is going to order restitution in the amount of $200 to be paid to the Crawford County Clerk to be dispersed to Michigan State Police. Crime victims assessment of $130, supervision fee of $30 per month while you're on probation, court costs of $325, OUIL reimbursement fee of $150, and $68 state cost. You do have the ability to seek an appeal of this sentence. Mr. Daniel, if you can let me know once Mr. Pritchard has.
Go ahead and date this, please, and then initial it. This is your appeal rates. Does he sign all three of them, Your Honor?
He is gonna want to do that, as two of them, he is gonna keep, one goes to the prosecutor and one comes to me.
Okay, just put your initials there, please. That's one.
Thank you.
Welcome. All right, there's the four copies here, so you keep one. There's an
He
extra one.
keeps two, one to the prosecutor, one to me.
Well, the prosecutor's
I
got
already have
one.
one.
He keeps two.
He keeps two, okay. Okay, let's do it differently. He has a bag of medications. You allowed to take that in or somebody's gonna, okay. All right, you all set?
Yes.
All right. Thank you. Thank you, Your Honor. All right, we'll talk to you later.
Oh, he's not coming. Well, I shouldn't say it that way. I have no expectation that my client, Mr. Woods, will appear today.
All right, we'll take that up next. We'll go on the record now. Eric Leland, this is file number 245280. The record should reflect Mr. Leland's present here. If I could have counsel with your appearance on.
Eric Hope on behalf of the people.
Adam Brown, on behalf of Mr. Leland, who's present, standing to my right.
Okay, this is set for a status conference today. Mr. Vernon, can you tell me what things are out of this?
So I will explain what we're going to be asking the court to do is ask for a short adjournment in this matter. Mr. Leland had at the last hearing requested appointment of new counsel. This court advised him that that had to go through MIDC. The statements made on the record were essentially that the court would refer this to Mr. Thompson, the MIDC coordinator. Mr. Leland took no steps to further that action. I contacted Mr. Thompson to see how that process was going, and he had taken no steps because he had not received anything regarding the request for new counsel. We had a couple conversations with court staff in Mr. Thompson's office, and determined that the process was actually that Mr. Leland would have to make that request himself to Mr. Thompson or to Mr. Thompson's office. He made that request. Mr. Thompson's office contacted me early last week with regards to my version of what had happened. We had sent a response to them yesterday. We got a copy, or we got a letter from Mr. Trush this morning identifying that the request for new counsel had been denied. It identifies in that letter that he has a right to appeal that decision to this court. I'm not familiar with what that process looks like, as I've never been involved in that process. But I believe Mr. Leland wishes to take advantage of that opportunity and have this court hear that appeal for new counsel. I would identify also that Mr. Leland and I have been struggling to formulate a plan going forward on how best to process his matter. There are certainly some questions that he has that I apparently have not answered satisfactorily. So I would ask the court to at least adjourn until the court hears the appeal on the new counsel issue. If the court's not inclined to do that, we would be asking for an appeal because, again, I think Mr. Leland has questions and concerns related to whether the plea is his best course of action at this point.
Okay. All right, Mr. Leland. How do you want to proceed? With the appeal. Okay. All right. Then I guess what I would need you to do, Mr. Leland, is put down down in writing, you have the ability to do that in the jail. I would need you to put down in writing the reasons that you believe that the court should replace Mr. Vernon. Are you asking the court to appoint different counsel for you, or did you want to hire your own attorney? Different counsel, okay. All right, appointed, yes, okay. Mr. Thompson.
I'm not sure how much I should say. So I haven't been part of Mr. Leland's request because I represent his wife, who's his co-defendant. So Mr. Trush has been. But in terms of appeal procedure, you can appeal to a different MIDC administrator. Typically, that's Mr. Slough. There's also court rule about the motions to the court about appointing counsel. So I'm not saying that's precluded, but MIDC use of the appeal would suggest it should go to Mr. Slough.
Okay. So, Mr. Leland, what I'd like you to do is submit again to. I'll get that right.
Correct.
Okay. So submit that, the reasons why you believe we should have different counsel appointed in writing, have the jail give that to the clerk's office, and we won't need to have a hearing. We can make that decision just based on your writing. Okay. And then, depending on that decision, we'll set this for another hearing at my next available date so that we can get it resolved one way or the other.
Quick question, so do I write it to, who do I write it to? Can I get a piece of paper that says
To the court,
just to the court?
yes. And just as well as you can, put on reasons why the court should. And then court will make a decision, you'll be notified of that decision. And then again, we'll have this set for hearing at the next available date. So do you have any questions about that?
Sure.
All right.
I have one, I don't know if it's for Mr. Thompson or for the court, but because Mr. Trush is the one who reviewed and responded to this, I can move to appointed as counsel if the court grants that request.
I'm not answering.
Yeah, I think that is set. Process.
Okay.
Whether it be Mr. Trish or whether it's outside.
Thank you.
Yeah.